Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of tenancy law, and that too in relation to waiver of termination of lease matters. To know more about it, please watch the video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button.
Hello everyone, I am Advocate Shweta Singh. Today we are going to discuss an important judgment which is titled as Shri K.M. Manjunath vs. Shri Irappa G. Dead through LRS. This judgment was pronounced on 24th June 2022, and in this judgment the Supreme Court has held that mere acceptance of the rent by the landlord after the expiry of the period of lease would not amount to waiver of the termination of lease. The facts of the case would be that in a suit for eviction filed by a landlord, the tenant took a contention that there was no valid termination of tenancy as per section 106 of the Transfer of Property Act. The trial court upheld the said contention after analyzing the evidence on record and dismissed the suit on the sole ground that there was no valid termination of tenancy and hence suit for ejectment was not maintainable. In revision petition filed by the landlord, the Karnataka High Court held that in view of section 111A of the Act, the lease would be determined by the efflux of time, and under such circumstances, notice of termination under section 106 of the Act was not required. It further held that mere acceptance of the landlord after the expiry of the period of lease would not amount to waiver of the termination of lease. Therefore, the defendant approached the Supreme Court by filing a SLP. The Supreme Court has held that the High Court rightly observed that in a suit for ejectment filed by the landlord, the material questions would be whether there was a jural relationship of landlord-tenant between the parties and whether tenancy was validly terminated. Obviously, the High Court found that initially the petitioner denied the jural relationship, but then he himself set up Exhibit D1 to D7, the lease agreements. As a matter of fact, there is now concurrent findings on the question of jural relationship against the petitioner. That apart that question need not be taken forward in view of the further contention taken by the petitioner in this petition. At paragraph 5.4 to the effect that he was originally inducted as a tenant as per lease agreement, which is Exhibit D1, and after the expiry of the period of the last lease agreement, he was continuing as a tenant in sufferance and paid rent till the date of filing of the suit. Further, the High Court was rightly and justified in reappreciating the evidence in exercise of its revisional power. A scanning of the impugned order passed by the High Court would reveal that the High Court appreciated the contentions as also the evidence on record to decide on the question of applicability or otherwise of section 106 of the Transfer of Property Act. The trial court itself took note of the factual contention of the petitioner that on expiry of period of lease under Exhibit D1 as per Exhibit D2 lease agreement, the lease was extended for a period of 11 months. While Exhibit D3 lease agreement, it was extended with effect from 1st 1/11/1990 to 30th 9/1991, and as per Exhibit D4 lease agreement, it was extended with effect from 1/1/1992 up to 30th 11/1992. Taking note of Exhibit D1 to D7 and the execution of lease agreement every year, and that the parties agreed to go by the provisions of the Transfer of Property Act, the High Court found that the lease could be taken as a lease for a period of 11 months. In view of the evidence thus obtained and taking into account the decision in Srimati Santi Devi vs. Amal Kumar Banerjee reported in AIR 1981 SC 1550, the High Court held that mere acceptance of the rent by the landlord after the expiry of the period of lease would not amount to waiver of the termination of lease. However, This court grants the petitioners a reasonable period of 6 months from today to hand over its vacant and peaceful possession to the respondents, provided the petitioner shall file an undertaking on affidavit in that regard to this court within 3 weeks from today. He shall also undertake thereunder to pay arrears of rent at the rate of rupees 1400 per month, and further to pay an amount of rupees 1400 on the 7th of every month during the extended period. Needless to say that in case of non-filing of such an undertaking within the above stipulated time, the benefit granted by this order would cease to exist and the decree would become executable forthwith without further reference to the court.